Hi, I'm Locke Meredith of Legal Lines. On our next show, we're going to talk about medical malpractice claims. That's claims against doctors and hospitals and healthcare providers. And we're going to talk about workers' compensation claims, and that's when you're injured while you're doing something for your employer, and how those kind of claims are really different from an automobile wreck claim. So join us on the next Legal Lines. Hi, I'm Locke Meredith of Legal Lines. Thanks for joining us today. Have on the show today Sean Fagan. He's an attorney here in Baton Rouge, and we're going to talk about the legal system and how it's been modified in particular circumstances, particularly regarding medical malpractice and workers' comp. Sean, thanks for being on the show.
All right, good to be here.
We've had a few calls that specifically asking us to talk about medical malpractice and workers' comp and why the rights seem to be different there. Let's talk about the medical malpractice first. When you sue a healthcare provider, it's not like suing somebody who runs into the back of you in your car, is it?
No, they've actually modified the regime to take it out of the court system initially, and you have to begin by going to what's called the medical review panel. That's been set up by statute through the legislature, and you have to go through jump through certain hoops before you ever have the opportunity to go to court.
Well, what it is the state legislature has determined that they're going to treat healthcare providers, because they provide a great service to all of us. You got to treat them a little bit differently. They've limited the amount of damages that you can collect from a healthcare provider, and they've limited the way that you prosecute the suit. And as you mentioned, first you've got to sue or present a claim against that healthcare provider through the medical review panel. And that medical review panel is made up of whom?
Well, you start the process by sending in a letter basically to the doctor and to what's called the Patient's Compensation Fund. Patient's Compensation Fund then notifies the doctors, and the medical review panel consists of a doctor, three doctors actually. One appointed by the doctor who's being sued. One is appointed by the person the patient, and then those two doctors then appoint a third doctor.
Now, there's an attorney chairman or a chairman of the medical review panel who's an attorney. And generally, these are guys who specialize in this area. They're very familiar with the process, but they really don't have a vote. The doctors are the guys that make the decision. Now, describe the process.
Process begins by just doing some basic discovery, finding out what happened, getting the medical records. Then the formal process begins with actually meeting with the medical review panel, presenting them with the argument and the evidence. Then the three doctors will get together and discuss the evidence and render a ruling.
And here's the deal. If you don't go through the medical review process and just file a suit without doing that, the defendants will generally object to the lawsuit, and you've got to go through this process first. Now, they can fail to object and you can prosecute the case, but I've never had it happen.
Generally, they'll object and make you go through the process itself.
And in a little more detail, basically, the court is involved to the extent that you can use discovery techniques, which is request for production of documents, meaning the medical records, and issue subpoenas to depose individuals or the doctor. And the court's kind of involved in that process, but not in any way deciding the merits of the case. And then there's a date set where there's the hearing, and you will present a position paper. The plaintiff presents a position paper that outlines what he believes happened and what the witnesses are going to say, and attach depositions and answers to discovery, and the defendants do the same thing. And then you go in and you meet with these three healthcare providers, and the attorney chairman presents your issues, see if they have any questions, and then you leave, go sit outside and wait for them to make a decision.
That's right.
And what decision do they 99.9% of the time render?
Most of the time it's a decision there was no malpractice committed. And to be fair to the physicians on the panel, it's an awkward position to be in, because by law you have to select physicians that practice in the same area that the doctor who's being accused of malpractice practices in. So inevitably they either know each other directly or indirectly, and it's somewhat difficult to sit in judgment of a physician knowing that 6 months down the road he may be sitting on a panel judging what you've done.
But the bottom line is they're charged with evaluating the information given to them fairly and equitably, but for some reason 99, it seems, I think there's statistics that say at least 99% of the time or 97% of the times there's not a favorable decision. Frankly, in my opinion, it's not a very productive way to litigate the claim.
And of course, after that's done, that's when you have the opportunity to go to the court system to have an impartial jury review the same evidence. The doctors who are on the medical review panel will have the opportunity to appear as witnesses
in court.
But of course, the jury then gets to review it all and make their own decision.
In fact, I think it's so important because they get to come in and testify as an expert on the issue, that is the medical review panel, that I have on occasions actually brought a court reporter to the medical review panel hearing, and when I've gotten a decision back, will question the doctors under oath why they found the way they found. What factors did they consider? What evidence did they think was not there that would support a claim? To find out exactly what their thought process is, to find out why they decided that there wasn't medical malpractice committed in that case, because they're going to testify in court. Mm-hmm. And it's an important thing to preserve their thought processes. Now, as you mentioned, after they render a decision, you don't have a whole year to sue again.
That's right. You usually have a certain limited period of time after the panel decision is rendered to go ahead and file the lawsuit. It's, I believe, 90 days after the rendering of the decision. And, of course, the other important thing is the medical review panel itself, you still have to file it within a year of finding out that or getting enough information to conclude that medical malpractice may have occurred. So the general provisions about how long you have to file a lawsuit also apply to the medical review panel.
It's also interesting when in pursuing this type of claim, frankly, the doctors or the healthcare providers have some defenses that are customary defenses that you have to deal with in the general tort area, and that is even though an event occurred that is not a favorable event, let's say a child's leg was cut off. They went in, were doing some surgery, they cut a popliteal artery, and the child, unfortunately, the limb dies because of it. That by itself, even though that's not an event that you would expect to occur, is not considered malpractice because the statute requires that the conduct fall below the general standard of care provided by doctors in the general locale. Now, that's a bunch of legal jargon, I know, so let's try and explain it in an understandable fashion.
Well, basically what that refers to is that the doctor has to do something that is below what a normal doctor and under the same circumstances would do.
And so, for example, in the case that I just gave, if it's not an event that never occurs, that, hey, when you're cutting the bone, sometimes you cut the popliteal artery, even though that's not something you want to happen, but if that's generally something that occurs on a frequent basis, not all the time, but frequent basis, then by statutory language, that's not malpractice.
It's consenting to the procedure, and a lot of times when folks go in, they'll have to sign a bunch of paperwork, and the paperwork a lot of times outlines the known risks. So the doctors are giving you upfront information to say, this could happen. We could actually cut this artery, and as a result, you might lose your arm. In other words, those are known risks. Of course, if it's a risk that's never been seen before, and the doctor makes a mistake during surgery, then he would be held accountable.
And the reason I want to point this out to folks is because so often a horrible event will occur, and it would seem to us lay folk that, how can this not be malpractice? And the case is tried to the medical review panel, and they say, no, it's not, or to the court system, and the courts say, no, it's not, and they just can't understand this because it's not a normal standard. Let's talk about that in the next segment. Locke Meredith with Legal Lines. We'll be right back with you. Welcome back to Legal Lines. I'm Locke Meredith. Have on the show today Sean Fagan. He's an attorney here in town. We practice together, and we're talking about medical malpractice and basically what the rights are, defenses, and how you prosecute the claim. Sean, we're talking about the fact that the attorneys have some bigger hoops to jump through and bigger hurdles to jump over to pursue a medical malpractice claim, and one of them was that even though it's an event that seems like it's malpractice, unless you have a doctor testify that the act that caused the harm is in fact malpractice, you really can't pursue the claim.
That's right. Any malpractice claim, once it gets to the trial stage, is going to require experts on the plaintiff's side.
It's an expensive kind of case to prosecute because you have to hire a doctor that's pretty much specializes in the particular area where the event occurred to testify, and those guys aren't cheap.
That's right. And the other side of it is, of course, that not all bad results mean that malpractice occurred. Just you said, sometimes unfortunate results come from surgeries that are done with the utmost care. The ones that, of course, we pursue and are interested in are the ones where it shouldn't have occurred. There's no reason to explain, or no logical reason why the doctor should have come up with this result.
And again, that's the reason we're talking about this, is so when folks go to see an attorney and they're told, we've had it reviewed by our experts and they don't think it's malpractice, I want the folks to understand it's because the law requires that there be an expert testify that the particular act or omission falls below what all the other guys normally would do. It's not that we're saying a horrible thing didn't occur. What we're saying is that we are not going to be able to prove your case at trial. Now, of course, there are times where there are experts, and generally we have to retain them from out of state because, as you mentioned before, a lot of doctors are friends with each other, or nurses or hospital administrators, and that's understandable. They don't want to say things bad about their friends or colleagues, and so it's expensive because you got to bring in out-of-state experts to testify about it.
That's correct.
The other interesting thing about a medical malpractice claim is even though a death may occur, or you lose a leg, or whatever the circumstance, horrible circumstance that may occur, the amount of general damages that you can collect are limited.
That's right. Under state law, and I believe it's really the only law that affects a profession where there's a cap on liability, but the cap is $500,000 in general damages.
And let's explain general damages. What we're talking about is damages for mental and physical pain and scarring and suffering and such. We're not talking about lost wages or the medical expenses associated with it. We're talking about the compensation paid to a person for all the suffering associated with the injury. $500,000 is it.
That's correct.
And of the $500,000, $100,000 comes from an insurance company that the doctor has, and then the other $400,000 comes from the patient's compensation fund. And because the healthcare provider only has a liability personally of $100,000, a lot of times they're not interested in trying to resolve the case in a settlement or anything. That's the reason so many of these go to trial, is because they got to pay $100,000 whether they lose or win, no matter what the damages are. A lot of times they say, why not, let's just roll the dice.
Well, generally most of the physicians are insured, and the insurance company that's insuring them, like you said, enjoys that limit of $100,000. So although it's a substantial amount of money, they're not exposed to anything in excess of $100,000. So if you have $1 million claim, that insurance company, the most it will have to pay out is $100,000. The other $400,000, which comes from the patient's compensation fund, that's a fund that's contributed to by all healthcare providers in the state if they choose to. And if they choose to contribute, they enjoy the benefit of the $500,000 cap, and that $400,000, that extra $400,000 comes out of that fund.
Well, it's an interesting distinction we need to make, too, and that is that the doctors or the healthcare providers that are going to benefit from this particular protection of the law that limits liability to $500,000, they have to be what's called a qualified healthcare provider. And if they are not, if they don't opt into the system and have a certificate that documents that they are in the system, then there is no cap.
There's no cap
on their liability.
There's no cap. There's no medical review panel necessarily. All those provisions in the Louisiana Medical Malpractice Act may not apply to those physicians at all. There's also been something that's happened within the last few years, and that is that nursing homes now are covered under the Medical Malpractice Act. So the same things the same benefits that the doctors would enjoy if they're participants in the plan in the program, nursing homes, if they contribute, also have a cap. Yeah,
they basically define who can benefit from this act, and it includes chiropractors, nurses, hospitals, physicians, a litany of folks who are protected and basically get protection, as I mentioned before, because the services provided to society are valuable. Let's talk about the fact that that's one category of folks who get special protection by the law. Let's talk about workers' compensation, because it's another limitation or modification of the general personal injury law as it relates to the amount of recovery that an individual can obtain if injured, and provides additional protection to employers. So first of all, let's define what a workers' compensation claim is.
Workers' compensation claim is when an employee is injured, the legal term is, in the course and scope of his employment, meaning he's on the clock, he's doing what he's supposed to be doing for his job, and in the process of doing that job, gets hurt.
And so we're dealing with the relationship of an employee with his employer, and also an employee who may be injured because of either defective machinery that his employer has, or unsafe practices that the employer is using, but also if a co-employee and if someone who works for the same employer does something wrong, their relationships are regulated, and the recovery is regulated by the workers' compensation law of the state of Louisiana.
That's correct.
All right, now let's talk about what the law does. First of all, the recovery, if I chop off my own foot, okay, no one else has done anything else wrong. I'm just an idiot and I chop my own foot off with an axe. I still get workers' compensation if I was in the course and scope of my employment, if I was doing something for my employer. Why is that?
Well, that's the true benefit to an employee. In other words, he's completely negligent. In the real world, outside of the workers' compensation world, he would get no recovery.
Zero.
Because he's at fault 100% for chopping his foot off.
So fault's not an issue?
Fault is not an issue. It's just, were you on the clock doing the job that you're supposed to be doing when the accident occurred? If you meet those criteria, you're covered. Now, the flip side is, and the balance that comes out, is in exchange for getting that benefit for...
So fault's not an issue, doesn't have to prove anybody screwed up.
That's right.
He gets some money, but...
In exchange for that, he's giving up if his action against the employer, if the employer does something completely boneheaded, such as taking off safety devices on equipment, and you wind up operating the equipment, you don't realize the safety device has been disabled, and you chop your hand off, and it's 100% the employer's fault.
Doesn't matter. You still get the same benefit.
You get the same benefit, but it's very limited.
Right. And the money that you can collect is actually scheduled. They have an amount set out in the law for the loss of a finger, loss of a hand, loss of an arm, leg, on down the line, death. Let's keep talking about the workers' comp law when we come back on the next segment. This is Legal Lines with Locke Meredith. We'll be right back. Welcome back to Legal Lines. I'm Locke Meredith. Have on the show today Sean Fagan, and we're talking about medical malpractice claims and workers' comp and some other anomalies in the law. We were talking about the benefits that you get if you're hurt while you're working for an employer, and they're set out in the statute. They're very limited. They're scheduled, meaning if you lose a member that's a certain amount, you also get paid. Well, the kind of benefits you get paid are temporary total disability benefits, which is what?
Well, that's exactly what it sounds like. If you're temporarily and totally disabled,
meaning unable to work,
can't work at all, during that period of time that you're totally disabled, you get, and that's different from the scheduled benefits we were talking about if you chop off something. It's a maximum of 2/3 of your income up to a maximum right now of $384, whichever is the lesser amount. So
it's a percentage of your average weekly earnings unless you meet a cap, and then it's just that cap.
Right. Yeah, we have plenty of times when someone walks in and they're earning $1,000 a week.
Too bad.
And the most they're to get after that injury is $384 a week.
The other type of benefit, of course, if they're permanently and totally disabled, they get that benefit for life, but that's very, very difficult to prove because they have rights under the Act to go and show that they can find you a job, you know, talking on a telephone or whatever, and they get basically a defense from that. The other type of benefits, of course, they got to pay medical expenses, but they have a right to send you to their doctors, who, based on my experience, aren't always particularly favorable to the victim. I'll leave it at that. They also pay you a benefit called SEBs, which is the difference between what you could earn had you not been hurt and what you're now capable of earning. That's a limited benefit, and it's deducted from the temporary total disability benefits you got because you couldn't work. It's an interesting anomaly. It makes no sense. In simple terms, you got 500 weeks of benefits generally. That's it. And at the end of those, no matter how long you screwed up. And that's for wage loss. Of course, your medical benefits can continue for the rest of your life. But the wage loss itself is generally limited to 500 weeks. Once you're no longer totally disabled and you could return to some type of work, that time clock starts to run. Let's talk about another unique aspect of the workers' comp law, and that is your employer has these rights under the Act, but not only the guy that pays your paycheck to you, but if he was hired by another, say, plant. Say Exxon hired Joe Blow's company to come in and paint the tanks, and I fall off the tank because the rope breaks. Well, Joe Blow's company pays me workers' comp, but let's say Exxon was the one that gave them the machinery to use, and it was defective. Guess what? Exxon gets to use the workers' comp law and pay me just workers' comp benefits if there's a contract between Exxon and Joe Blow company that says Exxon gets to consider me their employee.
That's right. Again, in simple terms, you'd say that Exxon is the general contractor, and then they have a subcontractor, which is Joe Blow. Joe Blow comes in, but before he comes in, before he can even walk in the door of that plant, he has to sign a contract that says if any of your employees are hurt while they're here, Exxon only has to pay workers' compensation.
Which is nuts. It's just not fair. It's taking the workers' comp statute way beyond what it was intended to accomplish, but it's the law, and frankly, it's something I hope that we can change over time. Let's talk about the fact that also in personal injury claims that there are rights of healthcare providers to make sure that they're paid for their services provided, and those are called liens.
That's right.
We have healthcare providers in the sense of the federal government, Medicaid, Medicare. If those guys pay, you better make sure that they're paid as an attorney, because whether or not you give them the money or not, you're going to pay if you don't. Bottom line is, if you don't make sure Medicare or Medicaid's paid, if they paid a medical bill, the attorney's going to pay for it. Now, we also have healthcare providers, doctors, physical therapists who provide services. If they send a lien letter, certified mail, itemizing the care provided, they have to be paid from settlement or judgment money also. And I'm not sure that a lot of folks understand that, including their health insurance.
That's correct. In which their health insurers can assert a lien, but generally in our practice, we see that every day where a healthcare provider says, listen, I've rendered these services, I want to get paid for it. Once they send us that letter, there's certain things they have to do it correctly, but once they do it, when our client comes in, we tell them this has to be paid first. We have no choice. This has to be paid to the healthcare provider. Even if the client says, I'll pay it myself, we don't have a choice.
No discretion.
No choice.
Which is fine as long as there's enough money. The healthcare provider should be paid. The real rub comes when a health insurance company who's getting premiums to provide health insurance coverage liens a case where there's very limited money available because there's limited insurance coverage, and they still want their money despite the fact that the victim is not being fully compensated, and despite the fact they've been paid premiums to provide that insurance coverage. And that's another area where, frankly, the law seems a little skewed, and there's certain steps that I would hope would be taken in the future by the legislature. Basically, what the principle is to make sure that the victim is made whole, and that's a situation where I think the healthcare provider has been protected a little more than the victim.
Sure. I mean, they're earning a premium for coverage, and if the victim says, I'm paying for automobile insurance, uninsured motorist coverage, let's say, and they're also paying a premium to the healthcare provider, well, if my uninsured motorist carrier is coming in to pay me because you didn't have enough insurance and you caused the accident, well, when my healthcare provider swoops in and says, well, thank you, Sean, for paying that premium to your uninsured motorist carrier, we get that money. I think all of us would sit down and say, now, wait a minute, I'm not paying that premium to these guys so that my healthcare provider can get the money back.
Let's talk about uninsured motorists. We've talked about it before, but it's just such an extremely important type of insurance to have. I think we need to talk about it again because we run into every single day situations where somebody will rear end or injure one of our clients, and they either have no insurance or they have a minimal 1020 policy, which means $10,000 in coverage, and our client's damages far exceed that. But since that's all this person has, that's all they can get, either nothing or $10,000. And oftentimes, the case will be liened by the hospital or healthcare provider for the total amount of insurance coverage that that person had that hit them. So the dilemma is, who else can you collect from? And the answer is, unless you have uninsured motorist coverage, nobody. So UM pays for your injuries and your expenses and your lost wages where the person who hits you doesn't have any insurance or doesn't have enough insurance.
That's right.
It's the most important insurance you can get.
It's unlike other forms of insurance when it comes to cars. Liability insurance, you're protecting yourself for harm that you've caused. Uninsured motorist coverage protects you for for harm caused by somebody else. Just like you said, where they don't have enough insurance or they don't have any insurance at all. In terms of the bang for your buck, we're not insurance agents, but we see this every day. And every client that I have that comes through here in an automobile accident, I tell them and ask them before they leave at the end of our representation, do you have uninsured motorist coverage? Because it's such an important coverage, it's so cost effective, and when you need it, you're never going to regret having it.
So if you learn nothing else from today's program, learn this. You need to have insurance, and don't let them sell you economic uninsured motorist coverage. Legal Lines with Locke Meredith. We'll see you next time.